site as well. Make sure y'all click the link in the bio, JE. In this video, I'm going to explain to you why it is a good thing when a dealership denies to rescind the security interest for your car, aka your car note. But first, I am not a lawyer nor an attorney, and this is not to be interpreted as legal advice. Now, what you guys are looking at on the screen is a notice of rejection to rescind from the law firm on behalf of a dealership. Now, the email that I received with this attachment, and it said, hey, look, they rejected it. They said no, they won't rescind. I need you guys to get out of your mind and stop thinking like a sheep, okay? A law firm, a public official told you, no, this isn't right. You're not supposed to do that, and you ate it up. You ate it up and said, hey, look, they said no. I'm trying to explain to you that them rejecting your notice of rescission works out in your favor at the end, okay? Per Regulation Z, they say that they have 20 days after notice of rescission to reverse all payments, give payments back in connection with the transaction, and release the lien, reflect the termination of that security interest, all within 20 calendar days. Not 20 business days, 20 calendar days. Then y'all know I had to pull it up. Now we're going to be looking at 12 CFR 1026.23, section D for dog, where it talks about effects of rescission. Now we're looking at one where it says, when a consumer rescinds a transaction, the security interest giving rise to the right of rescission becomes void, and the consumer shall not be liable for any amount, including any finance charge. Now 2 reads, within 20 calendar days after receipt of notice of rescission, the creditor shall return any money or property that has been given to anyone in connection with the transaction and shall take any action necessary to reflect the termination of the security interest. Keep following me, y'all. Now 3 reads, if the creditor has delivered any money or property, the consumer may retain possession until the creditor has met its obligation under paragraph D2 of this section, which we just read, okay? So if they have not met their obligation, returning the money, property, anything in connection with the transaction, if they haven't met that and reflected the termination of the security interest, you are to retain possession of said vehicle. Okay, let's continue. When the creditor has complied with that paragraph, the consumer shall tender the money or property to the creditor, or where the latter will be impracticable or inequitable, tender its reasonable value. At the consumer's option, tender of property may be made at the location of the property or at the consumer's residence. Tender of money must be made at the creditor's designated place of business. If the creditor does not take possession of the money or property within 20 calendar days after the consumer's tender, the consumer may keep it without further obligation. So for the people that be saying, oh, you have to give the car back, you have to give the car back, blah, blah, blah. You don't have to give the car back unless they have met their obligation by returning all monies paid in connection with that consumer credit transaction back to you, the consumer, and until they have reflected the termination of said security interest, which is your debt. Okay, so let's clear the air. No more, oh, they said no, they're saying people are doing this on social media. They're doing it. They're saying those things because they know that you will not fall through with arbitration to enforce rescission. This is why I tell y'all, we do not go to arbitration to rescind. We go to arbitration to enforce rescission. You send out that notice of rescission with purpose, with reason, okay? Even the beginning of the section of 12 CFR 1026.23, section A, where we at? A2. It reads, to exercise the right to rescind, the consumer shall notify the creditor of the rescission by mail, telegram, or other means of written communication. Notice is considered given when mailed, when filed for telegraphic transmission, or if sent by other means, when delivered to the creditor's designated place of business. You must put them on notice in order to rescind. So them telling you, oh, we reject this rescission, that's not lawful, and they're doing that because they believe that you are a sheep. They believe that you will back off. They believe that you will not read your arbitration provisions to enforce it. They believe that you will not continue on with court if arbitration falls through per the FAA. They believe that you will stop at where they tell you to. So think about